Your Honor, we're about to ask the court to set aside the final decree due to lack of notice to Ms. Wood. At the time the motion to set for trial was filed back in September of 2021, it was set, and at that time, the notice was sent to Jennifer No as attorney for Ms. Wood. Ms. No filed a motion to withdraw, which was not heard before the motion to set was heard. The motion to set was set on January the 3rd of 2022. The docket for the court shows that it was a no-show, that nobody showed up on that day. Then, 1 year later, in March of 2023, there is an order to set this for a final hearing. And it reflects that it's for a July 23rd, July 6, 2023 date. I'm sorry. Yes, the order to set date for final hearing says that it's going to be set on July 6, 2023. But it reflects, even though it wasn't filed. Oh, I apologize. I did that. I said 1 year later. It wasn't. I apologize. It was filed by the court on March 6, 2023 for a court date signed by the court on February the 28th, 2023. But the court looks at the docket January 3rd, 2022. So it was 1 year later. I was correct when I spoke earlier. There was a no-show. Nobody showed up for that motion to set. So no one was here to get a date from the court, but an order was then filed by Mr. McNabb's office, and it says it was sent to Heather Wood. This was subsequent to her attorney withdrawing, but it was sent in care of her father, Craig Martin. We have him here today. He did live at that address at that time. He has subsequently moved to Florida, and he flew in yesterday to be here today. But he will state that he did not ever receive anything at that address for Miss Wood concerning this divorce. They also, in the final decree of divorce, state they mailed it to that address. Again, Miss Wood would testify, and her father will testify, that it was never received at that address. At the time the motion was filed to set it, she had counsel. Counsel obviously did not appear on that date either, so I can only assume that counsel did not get the motion. Counsel subsequently withdrew. Then subsequent to her withdrawal, there was the order entered 1 year after it was filed, or supposedly heard by the court, setting it for a final hearing, and Miss Wood was not given notice. So we're asking the court to grant our motion to set aside. I would further state my client will testify that during this time, yes, she knew that a divorce was pending, but that her and her husband were having meals together. She was seeing her child on a regular basis, that everything was going along. She did not know that the husband was pursuing this divorce or that anything was going on, and she was not represented by counsel. So based on the sole fact that an order was entered setting this case when no one appeared in court on the day of the motion, we're asking the court set aside that final decree.
Don't leave yet.
Sorry, Your Honor.
If I understand correctly, there was a motion to withdraw. There was a motion to set for trial and award of primary custody of the child that was set for January the 3rd of 2022.
Yes, Your Honor.
January the 3rd of 2022, there was a no-show. No one showed up.
Yes, Your Honor.
Then on February the 22nd, a motion to withdraw was filed by Jennifer No, who was representing the wife at that time, and it was set for hearing March 30th of 2022. And it shows that March 30th of 2022, that motion to withdraw was granted.
Yes, Your Honor.
And the order was entered on March 31st. Then no activity occurred until March the 6th of 2023. And on that day, it was an order, simply an order to set the final hearing. And that was entered by me on the 28th day of February. It was not filed until March the 6th. and there was no motion to set the case for trial, according to the court file. It just appeared that it appeared on an order was entered, but there was no motion to set the case for trial, and an order was just submitted, and it was signed off on me, and I don't know whether it was signed off on the 28th day of February. There is no hearing shown in the court records of a hearing on February 28th, so apparently it may have just been an order to set the case for trial submitted to the clerk without anything else.
Correct, Your Honor.
All right. And then it was set for a hearing, and that was sent to Heather Michelle. According to this, there was a copy sent to Heather Michelle Woods, care of Craig Martin, at the address shown on Shahan Road in Ashland City. And that was mailed out on the 17th day of February. So is it your position that on the 17th day of February, your client, or thereafter, your client never received that?
She never received that. She'll testify that her first notice that this final decree had gone down was when she was served with the complaint for contempt by Child Support Services in October of 24. And up until that time, she'll testify that she was having dinner with her husband occasionally. She was visiting with her child, that they were just going on with their daily lives, and she did not know that he was pursuing this divorce.
All right.
Thank you.
McNabb, you want to respond to any of that?
Judge, this motion is, I assume, is a Rule 60 motion. 14 months after or 16 months after the entry of the final decree, assuming Ms. Crabtree is alleging some sort of fraud, it has to be filed within a year, so that grounds out. The other issues, whether or not she was served, papers were sent to her address. Testimony from the son's going to reveal that they talked about this. She knew the divorce was over. The husband's going to testify that she knew the divorce was pending. She had from March of 28th of, February of, the motion relieving counsel was March 30, 2022. She knew at that time that the divorce was pending. She had a chance to get counsel. She didn't. The case law is replete on the issue of what she's trying to assert. It's just, she hadn't been denied due process, Judge. She got a copy of the order. If this were allowed, anybody who got a judgment could say, I didn't get a copy of it.
How did this case get set for trial? Did you just send an order in to set it? There was no motion in the file to set.
The motion was filed to set. I looked at the docket entry, Judge. I don't know. I don't remember.
Let me assure you one thing. I've read through the file. There is no motion to set the trial. There's no motion.
There's a motion set for trial.
Pardon?
The motion was filed on the 28th of September
Yeah, there was a motion to set the trial in September of 2021, but the order went down 2 years later, or a year and a half at the latest. So,
Judge, assuming that's true, I don't know. I don't know what happened. I looked at the docket. Again, one would assume that I'm trying to commit some sort of fraud.
I'm not accusing you of fraud, Mr. McNabb. What I'm saying is that normally there's a motion to set a case for trial, and that way both parties are notified that it's going to be presented to the court to assign a trial date. Then both parties can be present if they choose to. In this case, the motion to set was filed in September of 2021, and it was no show. There was no one showed up for it. Then a year and a half at least later, in March of 2023, a simple order to set the date for a final hearing was submitted, apparently mailed in, and it was put into the file that I have to sign orders. And so an order was signed setting it for a trial, but there was never a hearing on the motion to set the case for trial. And that concerns me. I'm not saying you did anything fraudulent. I'm just simply saying there should have been a motion to set filed in March of 2023, prior to the court assigning a trial date. And actually, it would have been February of 2023 because that's when the order was actually signed. It wasn't filed until March the 6th.
I don't know how a trial date would possibly be secured. I don't know, Judge. I can't answer that question. All I know is that the case was set for trial. If she didn't know about it, if she didn't know about the trial date, it still doesn't make any difference. She got a copy of the final decree. And the final decree was final for 16 months before she took some action against it. So that's really the core of this question is from what she seeks a remedy is not from the motion to set or not to set or have a trial date. The remedy is from the final decree. The court heard the case, heard the divorce, signed the final decree. That's what she's seeking remedy from. And she's had a copy of that. It was mailed to her at the address that was provided not only to me, but to her lawyer, because the lawyer filed her motion to withdraw and sent it to the same address. No new address was ever given. I comply with the rules of procedure by sending her a copy of that. Testimony is going to be that she knew about it. She knew about the divorce. And that's the remedy she's seeking. Set aside the divorce. And I mean, it was heard by you. So we had a hearing.
All right, Ms. Myers, you want to put on your proof? I'll hear your proof.
William Craig Martin, Your Honor, he's my witness in the hall. And how do you know my client? Sorry, Miss Wood.
She's my daughter.
Okay. Did you know that her husband had filed a divorce from her?
No, I did not.
Okay. Have you ever at the address on Shahan Road received mail for her from Mr. McNabb's office?
I have not.
So are you aware of any documents that have been sent to her concerning a divorce?
No, ma'am.
No further questions, Your Honor.
Hold on.
Were you at any of the hearings in this case?
No.
Okay. You're aware that your daughter had a hearing earlier, right after the divorce was filed?
No, I was not.
Okay. So did you ever receive any correspondence from her lawyer at your address?
Not that I know of, no.
Okay. Not that you know of.
Nothing that I had seen
Okay.
or nothing that I had touched.
Did your daughter live with you at one point in time?
Yes.
Okay. When did she move?
I'm not sure when.
I'm sorry?
I'm not sure when she moved.
Okay. She ever received mail at your address?
Sometimes she did, yes.
She would go to the mailbox and get her mail and open it, so you wouldn't have any idea whether she got a letter or not.
Well, she probably wouldn't go to the mailbox very often, but I would just bring the mail in.
Okay.
And if it happened to be hers, I probably wouldn't pay any attention. I'm not going to look at her mail.
There you go. So something could have come in addressed to her that you didn't know who it was from and gave it to her.
I guess possibly.
All right. Okay. So you can't state under oath that she didn't receive any notification of a divorce hearing because you never did open any of her mail.
I did not.
Thank you.
Just to be clear, Mr. Wood. I'm sorry. Just to be clear, Mr. Barton. After she moved from your residence, did she receive any mail from an attorney?
No, ma'am.
No further question.
Hold on just a second. I have a question for you. What is your actual street address?
My current address is 424 Bimini K Circle, Vero Beach, Florida.
Back at the time that this was going on, what was the address on Shahan Road?
1365 Shahan Road, Ashland City, Tennessee, 37015.
And when did you relocate from that? When did you move?
I moved February 22nd of 2025.
All right. So in 2022 and 2023, you were living at that 1365.
Yes, sir, I was.
And if her prior attorney, Ms. Jennifer No, had filed a motion to withdraw and she shows that she sent that to your daughter at 1365 Shahine Road, Ashland City, Tennessee, 371015. That would have been where she was living at that time. That would have been back in
Yes.
February of 2022. I'm sorry, February 22nd of 2021. Was she living with you then?
I don't remember. I can't say that with it being 2025.
How was your mail received at that address? You have a mailbox?
Yeah.
Okay. Out by the road or on your
It's
house?
out, yes, it's out by the road.
Did your
but-
daughter ever receive the mail and go check the
Very
mail?
seldom. Most of the time, my grandson usually went to the mailbox and got my mail.
All right, thank you. Now you can sit down.
I called Heather Wood, Your Honor. You could have a seat.
What if you raise your right hand and be placed under oath?
Yes. Please state the full name for the court.
Heather Michelle Wood.
Ms. Wood, you're not denying that you were made aware that you were served with a complaint for divorce, correct?
Yes, ma'am.
Okay, so you knew a divorce was pending.
Correct.
And at that, initially you had Miss Jennifer No representing you,
Yes.
and then Miss No filed a motion and withdrew from your case. Is that correct?
Yes.
And that was back in 2021, correct? Or I'm sorry, in 2022.
Yes.
Okay. At that time, where were you residing?
At my father's place on Shahan.
And you were aware that Miss No withdrew?
Yes.
Were you aware that they filed a motion to set it for a final hearing in
No, ma'am.
September 21?
No.
Did you go to a court date in the beginning of 2022 concerning the motion to withdraw?
No.
Did you go to the motion for your counsel to withdraw?
No.
After your counsel withdrew, did you receive any other documents?
No, ma'am.
When did you move from the residence?
I moved in 2024.
So in 2023, you were living in the residence.
Yes.
Did you receive any documents from Terrence McNabb's office?
No, ma'am.
Attorney. Okay. And were you aware that this divorce had become final?
No, I was not.
Now, you were living at that residence. What was your relationship with your ex-husband and your child during that time?
Well, Levi came to my father's house every day after school. I picked him up on Monday afternoons as well as Friday afternoons from school at 2:45. He stayed most weekends with me and my dad at that residence. Matt and I talked occasionally when we had things to discuss about Levi. I did show at Levi's birthday party where him and his girlfriend at the time were there in 2023. That was around February 16th.
So y'all were going on your day-to-day life.
Yep.
And you were seeing your child on a regular basis.
Yes.
Okay. Did Mr. Wood ever say anything to you about the divorce being final?
No.
Did he ever say anything to you saying you owe me child support?
No, ma'am, he did not.
Okay. When was the first time you found out that this divorce had happened?
When I was served paperwork for contempt on child support on a Friday afternoon.
Okay. And you immediately retained me, correct?
Yes.
And we filed this motion.
Yes.
Okay. Now also, so why did you not pursue the divorce or do anything with the divorce?
I didn't have a lot of funds at the time. It was also during COVID, which everything was pretty much shut down for a period of time. He had filed the motion